Hello, this educational video is brought to you by the Colorado HOA Information and Resource Center. The topic of this video presentation is regarding the handling of elections in an HOA. The information provided during this presentation is for educational purposes only and is not meant to provide or to be construed as legal advice. Any legal questions should be directed to your attorney. Annual owner meeting, elections and voting in the HOA. We will cover some of the important concepts, procedures, and laws concerning voting under both the Colorado Common Interest Ownership Act, known as Kiowa, and the Colorado Revised Nonprofit Corporation Act. An important function of the HOA and its board of directors is the annual owners meeting. At this meeting, elections are usually held for the association board of directors and officer positions. Also, at an annual owners meeting, voting often takes place with regard to any community resolutions that need owner approval. And oftentimes, the HOA board presents the budget for the next calendar or fiscal year. Not only is it important to plan well ahead for this meeting, but also to garner as much interest, support, and attendance from the community for this annual meeting. Notice of the annual owner meeting. As per the Kiowa law, section 3833.3 meetings of the unit owners as the members of the association shall be held at least once each year. The owners shall be given notice not less than 10 nor more than 50 days in advance of the meeting, by hand delivery or by prepaid U.S. mail to the mailing address of each unit or to any other mailing address designated in writing by the unit owner. Also, the notice of the meeting shall be physically posted in a conspicuous place, to the extent that such posting is feasible and practical, in addition to any electronic posting or electronic mail notices that may be provided. The notice shall state the time and place of the meeting and the items on the agenda, including the general nature of any proposed amendments to the declaration or bylaws, any budget changes, and any proposal to remove an officer or member of the executive board. The record date. Check your association's bylaws in order to establish a record date for the purpose of determining the list of members who are allowed to vote at the meeting. The record date is important in that it establishes the voting owner list and, in the instance where only voters who are current in their assessments may vote, it establishes the date that owners must bring their accounts current in order to vote. If the bylaws do not establish a record date, the board of directors should set the record date. Commonly, the notice date or meeting date is used as the record date. Establishing a meeting quorum. A quorum must be established by the membership before any action can be taken at the meeting. It is a necessary requirement in order to hold a vote of the membership. In the Kiowa law, section 3833.3 of the Colorado Revised Statute, that section controls the meeting quorum, unless the bylaws provide otherwise. A quorum is deemed present throughout any meeting of the association if the persons entitled to cast 20%, or, in the case of an association with over 1,000 unit owners, 10% of the votes that may be cast for election of the executive board are present, in person or by proxy, at the beginning of the meeting. What is a proxy? It is important to get association owners to attend the annual meeting, or if they are unable to attend, provide a proxy to another owner to appear so that a quorum can be established and association business can take place. A proxy is simply an assignment of an owner's voting right to another person, in order to enable the proxy holder to vote at a meeting in the absence of that owner. It is a document authorizing a person to act on behalf of another person. Not only is it used for voting purposes, but also to establish a quorum for the meeting. The Kiowa law allows homeowners to appoint a proxy to exercise their voting rights. That proxy, however, is not valid if it is obtained through fraud or misrepresentation. The proxy document must be dated and terminates 11 months after its date, unless it provides otherwise. What language is in a proxy? Always check your association's governing documents to see if it states any required language for the proxy appointment. If not, it can simply be accomplished by an owner signing an appointment form, either personally or by the member's attorney-in-fact. Proxy delivery can be accomplished by transmitting or authorizing the transmission of a telegram, teletype, or other electronic transmission, like email, providing a written statement of the appointment to the proxy, except that the transmitted appointment shall set forth or be transmitted with written evidence from which it can be determined that the member transmitted or authorized the transmission of the appointment. Proxy assignment. The proxy holder may assign the proxy to another person, unless the proxy expressly precludes any assignment or transfer. The Colorado Revised Nonprofit Corporation Act holds that a proxy can be revoked by the owner attending the meeting and voting in person, or signing and delivering a written revocation of the proxy appointment to the HOA, or appointing a subsequent and different proxy. The association also can take action to reject a proxy appointment if its secretary, while acting in good faith, has a reasonable basis for questioning the validity of the owner's signature on the proxy document. If one were to contest the association's good faith and reasonable action to reject or accept a proxy, it would have to take place through the civil court system. Voting in an HOA. So what is a ballot? It is the document that the homeowner records their vote for the election of directors or other matters at hand that the association is asking the membership to vote on. If the homeowner of a unit is not attending the meeting and they have appointed a valid proxy, then that person will vote with a voting ballot on their behalf. What then is a secret ballot? A secret ballot is one that does not contain any information that can identify either the name or unit number of the person voting with the ballot. The results of a vote taken by secret ballot shall be reported without reference to the names, addresses, or other identifying information of unit owners participating in such vote. The Kiowa law requires the use of secret ballots in the following circumstances: when the association's bylaws require the use of secret ballots, when voting for contested positions on the board of directors, at the discretion of the board, or upon the request of 20% of the homeowners present at the meeting, a vote on any matter affecting the common interest community on which all unit owners are entitled to vote. How are the HOA officers elected? You'll have to look to your governing documents to see if the members elect the board members together with their respective association officer positions. For instance, president, vice president, secretary, treasurer, or board member at large. Oftentimes, the governing documents, the bylaws, of the association allow the acting board of director members to vote for the appointment to the officer positions. How are voting ballots counted? Ballots shall be counted by a neutral third party or by a committee of volunteers. Such volunteers shall be unit owners who are selected or appointed at an open meeting in a fair manner by the chair of the board or other person presiding during that portion of the meeting. The volunteers shall not be board members, and in the case of a contested election for a board position, shall not be candidates. Monitoring elections. In the case of a contested election or controversial matter being voted upon, some associations have utilized the services of a professional election monitor. This professional is an independent person well versed in the HOA law that can be hired to conduct and supervise the annual election for the board of directors. The appointment of this monitor may assist the HOA in holding a fair election and avoid costly litigation down the road. Can an association allow voting by mail? This is addressed in the Colorado Revised Nonprofit Corporation Act in Section 7, 127-109, where it states that unless otherwise provided in the association's bylaws, any action that can be taken at an owner meeting may be taken without a meeting through the use of a written ballot. Action taken under this section has the same effect as action taken at a meeting of the members. At times, an association may have the need to hold a vote on a particular important action by using a mail-in ballot. This may arise when there is a need amending the association's governing documents on an important issue that needs to be addressed prior to the annual HOA meeting, and where you need a large percentage of the ownership to approve the matter. Since in these instances there will not be a meeting, the information regarding any proposed action and the voting ballots will need to be mailed to all the homeowners entitled to vote, and then the owners will need to complete and return them by a designated date to the association. Unless otherwise provided by the bylaws, a written ballot may not be revoked. Mail-in written ballots and solicitations for votes by written ballot are required to state each proposed action, provide an opportunity to vote for or against each proposed action, and indicate the number of responses needed to meet the quorum requirements. In addition, mail-in ballots are required to state the percentage of approvals necessary to approve each matter other than the election of directors, state the time by which a ballot must be returned in order to be counted, and be accompanied by written information sufficient to permit each person casting a ballot to reach an informed decision on the matter. Approval by written ballot shall be valid only when the number of votes cast by ballot equals or exceeds the quorum required to be present at a meeting authorizing the action, and the number of approvals equals or exceeds the number of votes that would be required to approve the matter at a meeting at which the total number of votes cast was the same as the number of votes cast by ballot. What is an owner's forum? The Board of Directors should consider at the annual homeowners meeting setting aside some time at the beginning of the meeting for owners to bring up issues in the community that are important to them. It should be held, however, in a civil and professional manner with appropriate meeting guidelines established and consideration of time limits for owners to discuss their input. This is also a great opportunity for an association to present the required annual owner education for its members. This has been an educational presentation from the HOA Information and Resource Center. Following this presentation, you will find a short quiz and some HOA resources. Thank you for watching.